I'll be the last one left when the lights go out. I'm down to one last breath, but I can't stop now. We all fall down sometime.
Hello everyone, welcome back to my YouTube channel Legal World. Myself Dr. Seema Goyal. In the series of criminology and penology, today I am going to discuss one of the most important questions relating to the criminology and penology. My question is, define the term probation as well as the concept of probation. Also discuss its object. If we talk about the probation, that is an alternative model of doing the justice. It is also one of the most correctional technique for the treatment of prisoners. It avoids unnecessary prisonization and promotes the integration back into the community. With the rehabilitation, it helps in reducing the prison population and facilitates the administration of the prison and proper correctional treatment of the prisoners. If we talk about the concept and definition of the probation, the release of the criminal on probation, that is the treatment device that is described by the court, during which the probationer lives in the community instead of jail and regulates his own life under the conditions imposed by the court. Or the other constitutional authority as is subject to the supervision by probation officers. The term probation is derived from the Latin word probare, which means to test or to prove. According to M. Gutter-Friedson, probation is a procedure by which a convicted person is released by the court without the imprisonment that is subject to conditions imposed by the court. According to Donald Tuff, probation is a postponement of the final judgment or the sentence in a criminal case, giving the offender an opportunity to improve his conduct and to readjust himself to the community, often on condition imposed by the court and under the guidance and supervision of an officer of the court. In the case of juvenile probationers, non-criminal procedure is adopted. It is less formal, and the system of probation involves restrictions on the liberty of the probationers. It refrains him from disapproving behavior and compels him to perform certain required acts, which may be irksome or even the painful to him. Corrective measure supervision can be used in two ways, that is, before or after the custodial sentence. If it is applied before the custodial death, that is known as probation. But if it is applied to the offender who has just been released from a custodial sentence, then it is known as parole. According to Howard Jones, following conditions must be fulfilled before the benefit of release on probation to an accused person. Number 1, no punishment should be imposed initially. Second, offender should be given a definite period of redeeming himself. Third, during this period, delinquent should be placed under the supervision of the probation officer for the two reasons. First reason is in order to keep the court informed about the progress and to help him to make the best use of opportunity given to him. And the next reason, that is, if the offender responds favorably, no initial crime should be deemed to have been scrapped. But if he fails to do so, he may be brought back to the court and sentenced for the original crime as also for the other crime which he might have committed. If you talk about the object of probation, in Ramji Misar versus State of Bihar, in Ramnaresh Pandey versus State of MP, and Jagdev Singh versus State of Punjab, and Musa Khan versus State of Maharashtra, these are the cases where the object of the probation has been defined by the Honorable Court. In all these cases, the Honorable Apex Court has held that the object of the probation or the offenders in the certain words. The purpose of the act is to stop the conversion of youthful offenders into the hardened criminals as a result of their association with the hardened criminals of the mature age. In the case of youthful offenders who are sentenced to undergo imprisonment in jail, modern criminology says that nobody is born criminal and many crimes are the result of socio-economical milieu. Although much can be done for the 100 criminals, yet considerable emphasis has been laid on the reforming the young offenders not guilty of any serious crime by preventing their association with the 100 criminals. The Probation Offender Act 1958 gives the statutory recognition to this objective of this probation. This was all about the probation as well as object of probation. If you have any doubt, you must put down in the comment section. And don't forget to like, share and subscribe this channel for the further update. Thank you.
1, 2, 3, 4.